Your Honor, this is Mr. Valentine, whose matters, I believe, are at the end of the calendar, numbers 26, 27, and he has declined counsel and would like to proceed on his own. I believe
So
my office had been this matter before.
Yeah, Mr. Valentine, you had an attorney appointed and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again?
No, ma'am.
Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think anyone else in this court has my best interests for me.
All right. Well, first, there are a couple of warrants. I'm going to turn to the prosecuting attorney, Mr. Abid, first, and see what their recommendation is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative, the state asks that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is a case, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is here's sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct.
And were these, one, it appears, was an allegation of a breath sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that the 2024 allegation was included a refusal.
Okay. All right. So, Mr. Valentine, what the state's asking me to do is have you post about 30,000 cash or a bond bail, and consider those same restrictions that were on you before, that you show up at pretrial services, that you stay clean and sober, you stay law abiding, you give UAs, you be on a device that's attached to your person to make sure you're not consuming alcohol. What do you have to say?
I object to that, Your Honor. I did make my best effort to show up at court, even when I didn't show up, because I was confused about the dates. The clerk told me the wrong date. I showed up. I gave the clerk a letter. I wrote a letter to the court, and I also wrote counterclaims and responses to the State Attorney General's office, and I got no response from either. I went to try to squash the warrant. They told me that they wouldn't squash the warrant. They wanted me to either turn myself in, or they wanted to get me to pay more bonds. I have absolutely no problem showing up and representing myself. As far as...
Before we jump into this courtroom exchange, you need to understand exactly what you're about to witness, because this isn't just another routine hearing. This is a textbook example of what happens when someone walks into court convinced the law simply doesn't apply to them. At the center of this case is Mr. Valentine, who is attempting to argue what are commonly known as sovereign citizen-style theories, claims that courts lack jurisdiction, that legal definitions don't apply, and that somehow, by using specific language, he can sidestep the entire legal system.
Mr. Valentine, I'm going to hold you on 15,000 cash or bond bail on each of these independently. So you'd have to post bond to be released, as I find that you're a risk to reoffend and a risk to commit, another DUI or vehicular assault or homicide, given the history, while under the influence. So you're a danger to the community is what I'm finding. And you don't come back when we order you to come back. And you don't comply with court orders. So 15,000 cash or bond has to be posted on each one of these separately, and then you have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law abiding, in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns, and don't drive unless you have a good license and proof of insurance. I'm going to set another court date. We would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Well, what jurisdiction are you trialing me under?
What jurisdiction? Thurston County District Court, Thurston County, state of Washington.
That's not what, is this under a common law jurisdiction?
I'll have you research all that yourself, sir. I'm not going to argue with you. I have jurisdiction over you and over this matter.
So is this court operating common law, ma'am?
I'm talking to my clerk. 1 second. And make it clear, good, that he's proceeding pro se and that we need to do.
I am not pro se. I'm sui juris.
All right. You're proceeding without an attorney.
Did you take an oath to uphold the Constitution of the United States, ma'am? The supreme law of the
I
land?
sure did. I take it every time I get reelected, and I take it very seriously.
Will you be honoring that?
Very seriously.
Are you going to be honoring that
No,
oath
it's
today,
just
ma'am?
free trial, then we'll get it set for confirmation and jury dates.
Are you honoring that oath today, ma'am?
I sure am. And I do it every day.
So you think I'm a person?
I sure do.
So you think I can be bought and sold and regulated?
Right out of the gate, you can see the strategy forming, and it's already falling apart. Mr. Valentine is attempting to invoke something he calls Rule N, but the judge immediately clarifies the reality. Court orders don't come from individuals, especially not defendants. This is a critical misunderstanding of how the legal system works. Courts operate on established procedures, statutes, and judicial authority, not self-declared rules. What makes this moment so important is that it exposes a common pattern, using legal-sounding language without legal substance.
And at any time you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that.
Everyone, an attorney.
So we'll be back on September 20th, and you need to be back in court. If you're still in custody, we'll hear you in custody. And if you do post bond, you have an obligation to get into pretrial services within 48 hours and comply with them for sobriety monitoring. And that substance use monitoring program will pay for the scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, ma'am.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post stamps.
Offering you Thurston County Public Defense's assistance, I could.
Deny the right to defend myself. You want me to hire someone else to do it? I'm
not denying that, and I'm not going to argue with you, sir. So, at any time, we can talk about standby counsel, we can talk about counsel.
Everyone represented. I will continue to proceed sui juris.
All right, that's up to you. I got it. Okay. All right, well, let me turn to this state on the issues of the request for dismissal and well, one thing at a time. There are two different motions, and then the release conditions.
Your Honor, the state would strongly object to the court dismissing this matter. We're nearly 3 weeks away from trial. There's ample evidence to support that, to move forward with this. Additionally, an ineffective assistance of counsel claim is a matter for appeal. And so for Mr. Valentine to provide to even file that, we would have to wait for the criminal trial to come to an end. Additionally, on the hearing on October 18th, Judge Buckley provided Mr. Valentine with resources. I remember watching the Zoom recording, and that Judge Buckley informed Mr. Valentine that he would be provided with legal resources that would help aid him in mounting a defense against the state. So the state would wholeheartedly object to the motion to dismiss. Regarding the conditions of release, we also talked about Mr. Valentine brought this motion, the same motion, on the 18th, where the court denied that motion as well. Part of the facts underlying that is during that time, the state did move to dismiss one of the DUIs at that time. And so based on that, the court still found that there was a real concern for public safety. And so the court still kept the bail imposed. Additionally, from the 18th to today, according to CRR LJ 3.2, the court can only modify conditions if there's a change of circumstances, new information, or a showing of good cause. And there's been nothing within the last 10 days that has shown that has been provided or mentioned that would fall under one of those, except one of those reasons. Additionally, I've received information earlier today that the state has received talks report from the DUI that we dismissed a week on the 18th.
Well, let's stay on this case alone.
And so the state would have some real concerns on whether
let's just stick to this case and not bring in any other facts from any other case.
So based on that, there's been no...
Now this is where the tone shifts from unusual to serious. The judge lays out a $15,000 bond per charge and clearly explains why. Risk to reoffend, public safety concerns, and prior noncompliance. This isn't theoretical anymore. This is the court taking concrete action based on behavior and history. Notice how the judge emphasizes conditions like sobriety monitoring, no driving without a license, and avoiding alcohol entirely. These aren't random restrictions. They're directly tied to the charges and the risk assessment. While Mr. Valentine is focused on abstract arguments about jurisdiction, the court is focused on preventing harm in the real world.
Who were booked,
Are you also talking about a case that's not this case, or is it this matter you're talking about?
I'm referring to how the prosecutor had other charges pending, which was a condition.
I'm not going to consider any other charges, either side. Let's focus in on this one and this one alone.
Okay, so for the charges, I would be challenging the evidence that the state has. I don't believe they have probable cause. The trooper is claiming that I almost struck him. I did not almost strike him. And it's clear that there's discrepancies between his report and the video footage that I observed. I am not a danger or threat to public safety. I caused no harm. I cooperated with police. I pulled over when I was asked. I've been operating in good faith and have come to court and tried to resolve this to my best effort. I did a DUI impact panel. I was on an ankle monitor, and I've been in here for multiple months now. I think I've shown that I am operating in good faith, that I am trying to get this resolved as soon as possible, and I would ask that you consider that. And if I may add, Your Honor, I was never cited for any traffic violation. The state trooper made an assumption claiming I almost hit him. His back is to the camera as I'm passing the vehicle. I did my due diligence and gave him room because they're standing right on the shoulder line of the side of the road. I moved over and gave them plenty of room and went around them. And that's clear in the video that I was never close to striking his vehicle or the pedestrians on the side of the road.
So disputes as to evidence, I mean, that's why we have trial scheduled. You'll have an opportunity to cross-examine all witnesses that are brought by the state. And of course, any witnesses will be available to both sides so that American National Valentine has the opportunity to question them. So who's on your witness list stays on your witness list. I found that discovery has been provided. I'm not finding it's untimely, given the 3 weeks we have till trial. As to release conditions, the unfortunate part is I'm not going to change those conditions of release. They've been reduced to 5,000 cash or bond, and that you stay clean and sober and law abiding. And but given the amount of time we've had to issue warrants to get you back before the court, that's really a big part of why you have to postpone to get back in, and also because DUIs do pose a danger to the community.
Here it is, the classic jurisdiction challenge. This is one of the most common tactics used in these types of arguments, repeatedly questioning the authority of the court, hoping to create doubt or force a dismissal. But the judge's response is calm, direct, and consistent. This is a district court in Washington state, and it has jurisdiction. End of story. What's fascinating is how persistence is being mistaken for effectiveness. Just because a question is repeated doesn't make it stronger. In fact, in a courtroom, repeating already answered questions can actually hurt your credibility.
Misconduct, I haven't found any, I don't have enough evidence here to show that anyone was acting wrongly. If there is an ineffective assistance of counsel from before you chose to go representing yourself, then you would have to show how it applies if you're convicted, how it applied to that conviction, and if there was in fact ineffective assistance of counsel, but you're representing yourself. So that's, and it doesn't make a whole lot of sense right now.
I'm not doing that because counsel was ineffective, and the last judge denied me access to court and obstructed my constitutional right to speak. Isn't that grounds of misconduct, ma'am?
I don't find, I don't have enough evidence to find that. So
Well,
that's the issue.
I have witness statements that were submitted to the court. My family showed up at court and witnessed the judge not let me speak, not let me present my judicial notices or motions. And it's also recorded that he did such.
So I know you disagree with the court's decision.
To the fact it was misconduct?
I don't find misconduct. I don't have enough evidence to find that. And so we're set for trial confirmation November 8th. I'm going to keep everything set as is. Trial is scheduled for November 18 and 19. And if you postpone, then you bring yourself in. If you don't, then we'll be sure that you're there. The facility will be sure that you're there.
I'm indigent, ma'am. I cannot afford a $5,000 bail. Is there any way we can bring that down anymore?
And again, I'm not going to change that bail amount. We've reduced it already earlier, and I don't see a substantial change in circumstance is what Rule 3.2 requires of me. So everything stays the same. All right, so covered everything. Yep.
To a higher court.
You can always go to the Superior Court and ask for a writ to overturn any of the district court's decisions. But right now, we're still proceeding to trial until which time the higher court tells this court to stop or to do something else.
Yes, I am.
So that's it for this afternoon. I'm just going to send you down notice again of all the court dates so you have them. And then we're back November 8th is our next court date. And you have that in hand. All right. I think that's it for the afternoon. Thanks, Mr. Thanks.
I had one more question.
Yep.
So I still have to have a scram bracelet and can be released on my first DUI. Isn't that for people who have previous convictions of DUIs?
It can be. It can also be because of a history of use and a nexus to that.
Where is that history of use?
Well, we've got things, let's see.
This exchange perfectly captures the core misunderstanding. Redefining words doesn't change the law. When Mr. Valentine starts questioning whether he's a person, the judge responds with something both simple and powerful. Rights under the Constitution apply to persons. If you're not a person, you don't get those protections. That's the irony here. These arguments attempt to escape legal responsibility, but they also undermine the very rights they depend on. The judge even points out he's not interested in semantics, and that's key. Courts deal in legal definitions, not philosophical reinterpretation.
Here for confirmation of that jury trial that's scheduled for the 18th and 19th. So the question is I see that you filed several motions, had a time to kind of look at generally, looks like there are some motions about evidence in there that need to be heard at the time we start trial. So we'll do that. Otherwise, all the rest we'll just hear the day of trial, get that figured out. Are you prepared to go to trial on the 18th and 19th?
No, I'm still waiting for some documents from the Office of Assigned Counsel, a request for stipulated facts, the case transcripts, bonds, and bar numbers of the individuals of the case.
Okay, let me ask you, how is that going to impact your defense at trial?
Because I need to go over the documents and the case transcripts, things that I've submitted and things that have been done by government officials in the case previously.
But what does it have to do with your defending against the charge? That's what I'm trying to figure out. So that may be something that you want to, I'm not sure what you want to do with that. If you're thinking that there's governmental misconduct or ineffective assistance in counsel, or you want to make a bar complaint or something.
All of the above.
Yeah, that doesn't impact the issues as to bringing a trial forth on the charges.
Well, it does, because I'm going against the state, and the state's governmental misconduct is a direct effect of how the case is turning out.
Okay, so let's put that aside. Would you be ready to present your defense?
Once I get those documents, I will be able to.
Okay, all right. And so those documents would be transcripts of the court records.
Yes.
And
a request for stipulated facts.
I don't know what that is. Stipulated facts. What do you mean by that?
That line from the judge is absolutely, your consent is not necessary. And that's something a lot of people misunderstand. The authority of the court doesn't depend on agreement from the defendant. If it did, the entire justice system would collapse. This moment is almost a reality check. Mr. Valentine is asserting non-consent as if it's a legal shield, but the judge makes it clear that it's irrelevant. Court orders stand whether you agree with them or not. And here's a question worth thinking about. If simply refusing consent could override the law, what would stop anyone from doing the same?
For example, like the state of Washington and Washington State being two different things.
Okay, they're not. I see that you may think they are, but effectively in law, they're not. It's not an issue here. Let me just kind of look at some of the things you filed and see. Okay, so, all right, transcript of past hearings. Something from the prosecutor that I can't quite figure out. You want information about the previous attorneys that may have represented you for a short
I wanted the communication between previous counsel and the prosecution, the case transcripts, and the bonds on record and oaths of office.
Okay, of the oaths of office of the prosecutor. Who?
You and the prosecutor, and for the attorneys that I previously had.
Well, for me, you could just go to the auditor, state auditor, or in the city or the county auditor. They have everything there. Prosecutors, you can always ask the prosecuting attorney's office.
The Office of Assigned Counsel can't provide me with that.
You can certainly, ask them too. Ask them for their people what they have. I can't say.
Okay, I haven't got a response yet. I've sent the email. I've called them and sent the email.
All right. So again, you're representing yourself. Still trying to figure out how those are impediments to
Because even though I'm
Taking this
representing
before.
myself, the court is still obligated to provide legal assistance.
The court isn't supposed to provide legal assistance to either side of you. We're supposed to make sure things are done right and fairly. I can't assist you in your trial. That would be wrong because I can't assist the state either in their trial.
Don't I have a constitutional right to counsel?
You do, and we did appoint Thurston County Public Defense at one point.
So yes, they are appointed to provide legal assistance for me.
Yeah, and so
When I put in my motion, I said that I didn't want to be represented, but I still wished to have legal assistance.
yeah,
I just
well,
don't want anyone speaking for me.
so you want standby counsel is what we would generally call it. Someone who would pretty much sit in the audience, and if you wanted to step back and ask a question of them, you could ask a question of them. A lawyer from Thurston County Public Defense. That's pretty much the utmost of what a standby counsel does. Is that what you're asking for? Because
I'm asking for legal assistance. It's my understanding that I have a constitutional right to counsel.
sure.
And so I'm asking that the state in some manner provide me with someone who will assist me with my legal affairs. I don't want to be.
Now the stakes get even higher, because this isn't just happening in isolation anymore. His family is present, watching everything unfold. And the judge takes a moment to deliver what might be the most honest advice in the entire hearing. Representing yourself in a case like this is a huge mistake. This isn't intimidation, it's reality. The judge even explains that he will hold Mr. Valentine to the same standard as a trained lawyer. That means understanding procedure, evidence rules, filings, everything. And without that training, the risk isn't just losing. It's making things significantly worse. There's also a deeper layer here.
I
So
communicated with Office of Assigned Counsel. They assigned me someone,
they did?
to help
Okay.
me. So
I didn't know
as
that.
far as I knew, that's what was going on.
All right. Have you talked then? I'm kind of wondering why someone's on here. All right. So since that you need to, have you had contact with that person since
Yes,
that
it's someone with the
appointment?
last name Thomas. I don't have it written down, but yeah, I've called and sent him some emails. I got him from the supervisor.
Mr. O'Connor?
Yeah, Mr. O'Connor,
Okay.
yes. He told me
All right.
someone, I think Alex Thomas or something like that, was
Okay.
someone he referred me to, and I've contacted them, but I haven't got a response back from them.
And when was that?
This was just before I got out of jail, so
Just the end of last month?
yeah.
Somewhere around there.
Yeah.
Okay, or beginning. All right, well, so we're like 10 days to trial. You haven't talked to the attorney that's public defense has provided for legal assistance. And so is that part of why you're
Yes,
not
ma'am.
ready to go? Okay,
Yeah.
because that makes more sense to me. All right, well, let me turn to Mr. Abid, who's representing the state on that issue.
State would have no objection to a short set over, Your Honor.
All right, so now, just so you understand, you're asking for a continuance. It's a fair request. I would find what we call good cause for that request. But that would put us into an excluded period under the time for trial rules. And we would set another confirmation date, and we would set it, actually, we'd set a motion date, confirmation date. Let me look at these motions.
And just like that, we've reached the end of a hearing that perfectly illustrates the gap between belief and legal reality. Throughout this case, the judge remained consistent, focused on procedure, safety, and the law, while Mr. Valentine stayed committed to arguments that simply don't hold up in court. The key takeaway here is simple but important. The legal system operates on established rules, not personal interpretations. Challenging authority isn't inherently wrong, but doing it without a valid legal basis can have serious consequences, especially in cases involving public safety concerns like this one.